from the shores of beautiful Lake Coeur d'Alene in the heart of North Idaho. Local, regional, national, and international guests discuss their topics on our forum, the North Idaho College Public Forum. With your host and moderator, political scientist, Tony Stewart.
It is our pleasure to bring you a two-week series, and our subject is going to be mediation and conflict resolution. In order to carry out that issue both this week and next week, I am very pleased to welcome to our program Sheila Penelope Fisher, who is an attorney here in the state of Idaho. She is also an approved mediator with the Idaho court system. Our guest holds a BA degree from the State University of New York at Old Westbury, and she holds a Doctor of Jurisprudence from Rutgers University in New Jersey. Welcome to our program. We're very pleased to have you here, and thank you for taking time to do this two-week series with us.
Oh, thank you so much. It's totally my pleasure.
Thank you. And as always, I'm very pleased to have our two regular panelists. First of all is Janelle Burke, who is an attorney in the state of Idaho, and next to her is Steve Schenck, who is the Vice President of College Relations and Development at North Idaho College, and I shall invite Janelle Burke to commence the questioning on mediation and conflict resolution.
Sheila, there are a lot of different forms of conflict resolution. There's alternative dispute resolution of different kinds. Can you explain to our viewers what the differences are between some of those kinds? For example, arbitration and mediation.
Surely, Janelle, I'll try to. First, I'd like to just explain, to put this in a context, that one way of resolving disputes is to go to court, and that's kind of the old-fashioned way. And now you're starting to hear more and more about alternatives to resolve disputes outside of that court setting. And the kinds of alternatives that have evolved have different methods and different purposes, I suppose, to some degree, and different results to some degree. One of them is mediation, and mediation is essentially a process by which a trained neutral mediator assists parties in a dispute to reach a mutually agreeable, acceptable agreement to their dispute. And they do that through the facilitation of the mediator, who helps them identify issues, reduce the amount of misunderstanding between the parties, helps them clarify their priorities and look at their interests in resolving the dispute, helps them create, generate, and evaluate different options for settling the dispute, and then helps them find points of agreement, hopefully. And then the parties themselves actually construct the agreement that is mutually acceptable to all parties concerned. It is not a process by which the mediator imposes any kind of settlement on the parties at all. All the mediator does is essentially guide and guard the process itself so that the parties are best able to reach negotiations in a reasonable format without throwing things and walking out of the room. And sometimes it doesn't work. But arbitration is a setting in which the mediator's almost acting like a judge. It's almost like taking the court system and just removing it to a private setting, although not exactly. And honestly, I don't know a lot about arbitration because I don't do it, but the little that I've learned in mediation trainings is that it involves the arbitrator imposing a decision, listening to both sides, akin to the way a judge would, evaluating the information along perhaps a more legalistic type line than would take place in mediation quite frequently, and then telling the people what the answer is. And then there are also other forms, such as you could get a special master in a court case, and the court would refer the matter to a special master who would then assist the parties in evaluating the legalistic side of the case and then make a recommendation back to the court.
Steve Schenck.
Typically, do you get involved because the parties that are in dispute have been presented that as an option and say, yeah, that sounds like a good idea, or is it a court-ordered situation?
It's typically the first. There is the ability in Idaho now under new court rules for the court to order parties into mediation, and that does occasionally occur. And I don't know whether it will eventually occur more regularly. It certainly could be ordered more regularly, in my opinion, but it's the rarity right now. Whereas just learning about mediation as an alternative probably is being presented by parties in a formal legal dispute through their attorneys.
Do the courts have this recourse available to them primarily or exclusively for civil matters, or do you also sometimes work with individuals who might be in a domestic dispute that could even involve violence? Is it either of those cases or one or the other?
It can be either of those cases. It started out when I first received training in mediation in '92, I believe it was. We were told that, oh, no, you can't touch domestic violence. Oh, no, you can't touch criminal matters. That's all changed. And it's very popular and very ensconced in some communities, although I'm not aware of it being formally ensconced widespread anywhere. But there are certain places, including Kootenai County, where there are different kinds of interventions and diversions in the criminal format, which do involve mediation.
Is this a fairly recent phenomenon?
Yes. Yeah, I don't know how recently the prosecutor's office here included this kind of, it's called victim offender reconciliation programs. And I don't know how recently the prosecutor here began doing it or exactly what delineates the scope of their program. I'm not sure if it's just juvenile matters or any matter. But
how about in the civil court side of the ledger? Is that also a fairly recent phenomenon, the use of mediators?
Well, I would say, Janelle probably knows exactly when the rules changed. I think it was '96.
Although before the rules changed, there was already a sizable amount of mediation going on. A settlement week started in Kootenai County in 1990, which was just civil cases.
I see. Thank you very much.
Oh, surely.
I know a lot of our viewers would like to know more of the mechanisms that you and others, we have a number of attorneys who are well trained in mediation. It goes back many years. In fact, there is the Inland Northwest Conflict Resolution Center here, and there are individuals who deserve so much credit. Sue Flamme as an attorney that's a good example of this, and Heidi Fisher, and there have been others, and Janelle is very familiar with that, and they've worked on this a long time, and they were really pioneers in getting the courts involved in that this is a system that really works. And so with that little background, and now you're a part of this process, let's call upon your training in mediation. I'd like to get into some specifics, some procedures. Again, not revealing any invasion of privacy, but if two parties have a conflict and you may be the person that's going to work as the mediator, give us some rules of do's and don'ts. I know there's a lot to talk about now. There's also in labor management where oftentimes they'll bring in a facilitator, a mediator, or arbitrator. There's these different levels and different extensions of influence and power. But I know there's books written on the do's and don'ts, or getting to yes, and so forth. Let's start with the idea that before you ever have a session, aren't there some ground rules that are essential to try to bring success to the table?
Yes. Well, the method that I prefer and that I've constructed for myself based on different trainings I've attended starts with the issue of laying ground rules.
Sure.
And involves the parties. I don't impose this on the parties in mediation, but I make clear to them that before we can really enter the process, everybody needs to understand what they're getting into and how it's going to work. So we really spend a great deal of time concentrating on that, and sometimes I worry that I'm going to lose them before we get started because it might be getting a little bit too, when are we going to get going? But it's really important. One of the most important things is to stress confidentiality to the parties so that everybody understands that I am not going to reveal what has gone on in our sessions at any time. We are protected as mediators under court rules from being required to come into court and testify about what goes on. We have absolute privilege.
If you don't have that, you wouldn't have any success. in most cases.
Probably not. So that's important for the parties to understand. And then we work on constructing a set of ground rules that works for everybody. Ordinarily, it's simple things like agreeing that you won't interrupt each other. You'll try to keep your voice down to a nice, normal conversational tone. You won't get out and leave precipitously, stomp around, intimidate each other, interrupt, this kind of thing. But you have to work with the individual people and their individual styles and needs. Some people, for example, might be really offended and concerned to hear somebody raise their voice or swear. And other people, it might just be their normal form of communication, and they might just need to make that known right then and there. I need to feel free to express myself the way I am and get used to it. And so you work together to construct those guidelines.
But since they have such conflicts, or they wouldn't be there,
Yeah.
part of that is evolved out of oftentimes maybe a lot of hurt, and it's become very personal. Do you increase the chance of success if you can get them to agree that we'll lay on the table the issues that are to be resolved? But in doing that, we have to confine ourselves to the issues, and we cannot engage in personal attacks. Because, and I'm thinking probably more in another arena when you're dealing with employers and employees, if you can't get that out of the way, you may lose the issue itself.
Well, it's an interesting process, and you hear this word process and like, oh, come on already. But in fact, it's almost like a magical thing for me. I really believe in the process itself, and I have found that the more people are able to actually vent those emotional issues, the more successful the mediation will be. It's really got to happen. If it doesn't happen, usually the parties won't reach an agreement, or they won't abide by the agreement that they pretend to reach.
I sound like I'm harping on this point, but what if one of the parties starts calling the other one names, and the other person's going, you have a rule they shouldn't walk out, they may say, I'm just not going to take this, it's too offensive.
Well, certainly, absolutely. And that's why they invented this brilliant little concept called a caucus.
Okay.
So I just want to kind of go back a
Sure.
moment and explain this. You were talking about, is it criminal or civil, or what kind of cases do you get? But basically, what happens is that there are some kinds of situations in which it really pays to keep the parties together and to discuss the problem and the solution to the problem, and generate these options and emphasize your priorities and all of that stuff together. And then there's other times when you get the sense, or from the get-go, we're going to have to separate these people quickly. And in the case of, for example, an employment dispute, you might quite likely separate the parties very soon. And so the way it would work is you would set up your guidelines and agree, we're going to discuss things in a nice normal tone of voice, and nobody's going to interrupt and all that. And then the mediator will ask each side to present an overall summary of what they see as the problem. Just an overall, a quick little 2-minute synopsis of what's going on here. And each side will listen to the other side, and then you'll break right from the get-go. You don't give them a chance to call each other names. But you have agreed that we're going to sit here and listen to each other and not interrupt. So you'll tell me your side of what's gone on, and this person will say their side. And then immediately you break. And you explain that in the introductory process. You discuss confidentiality, guidelines, and the idea of the caucus and what its purpose is. And its purpose is for each side to be able to explain to the mediator in greater depth and detail exactly what's gone on and why they've got a problem, why they've had a problem resolving their problem. And that's the point at which you hear a lot of high tones and excitement, but it's private. The other side is busy doing something different. When you split apart, you give one side essentially some homework. Think about this, tell me about that. And there are times when parties attend the mediation together with their attorneys, in which case when you're caucusing, the party is there with their attorney, so they have some company and they aren't just sitting there twiddling their thumbs, and they have some incentive to keep talking about the thing.
During the caucus, then each side may bring back some proposals for a compromise.
Exactly, and when there are other settings to review for a second where you won't break up, and more typically those seem to be the family kinds of disputes. Quite often nowadays, mediation is being used in divorce cases to resolve anything that the parties can resolve so that the judge doesn't have to impose that decision on them. And so frequently those are at least the custody and visitation kinds of issues, if not also the property issues. And in those kinds of situations, occasionally you may need to break the parties apart and do some kind of a caucus. For some reason, I don't quite understand, family lawyers historically, routinely don't attend mediations together with their clients, and I'm not quite sure why. But it works fine either way, whether the attorney is there or not.
Thank you. Janelle Burke.
I want to give you an opportunity to explain some of the advantages to mediation. Why should people try this alternative dispute resolution, or why would this be an advantage to go through something where you kind of reach the agreement on your own?
Good. Well, I think it's really important to try it just about any time that you feel that there's something out there to negotiate. So that's pretty wide open. There are certain times when parties probably won't, I don't want to say succeed in mediation, but there are probably certain instances when there's no particular reason to go into mediation. Those would be times when, for example, there's absolutely nothing to negotiate and both sides agree, and you've tested the waters and you've concluded, yeah, you're right, there's nothing to negotiate here. That's pretty rare. There are times when, for one reason or another, one of the parties absolutely wants somebody else to make that decision for them, or isn't themselves capable of entering into the process of formulating the decision themselves. Perhaps in a case where there's some kind of incapacity involved, I could imagine that kind of a situation. There are times when, for one reason or another, one of the parties or both of the parties absolutely wants a judge to make the decision. They want a rule of law, and that's that. There are times when there's an absolute dispute about the law, and there's no sense in the parties arguing about, yes it is, no it isn't, about whether this legal decision means this or that. They're going to have to go to court and have it decided in that manner. And there are times when people are breaking new ground in the law, and the only way to set that new law is to have a court decision. Everybody else probably should at least try it because it's got such wonderful benefits. The best part about it is that the parties themselves control the outcome. And so it's like you hold the key to your prison. They can let themselves out at any time along the way, provided that they have the proper guidance and ability. And so it's very, very win-win. And parties who participate in mediation either reach an agreement that they're very happy with, or even if they're incapable of fundamentally solving their problem, they usually come out of the process so much happier, so much more relaxed, so much more focused, and so much more willing to get on with things instead of harboring a grudge and just being angry forever about the outcome.
Steve Sheen.
Sheila, what about cost? I don't think in the scenario that you just painted for us, and it was a very good explanation, but I don't think you mentioned cost. Is it typically far less expensive to settle things through mediation than it is in the courtroom?
Horrendously less expensive.
Big factor?
It's amazing how often mediators tell about mediating a case which has gone on for years and years and years between the attorneys involved, and nobody thought it could be settled, and it can settle within minutes, hours, a few days. It's so short and easy. It's amazing. It's really spectacular. And so cost is a wonderful consideration. Absolutely.
Would you say that that's the case, especially these miracles where a resolution is reached relatively quickly in a case where no one thought that it could happen? I'm not an attorney. We have one other attorney here and a political scientist, which is the next best thing, I would think.
Absolutely.
How much of that is the difference? You are an attorney, but did you find your law school training far more adversarial, and the training you received as a mediator much more of a what's the right word for it? A collective process, a reasoning process. If that's enough for you to answer the question, I'll just be quiet.
Yes, I think the word you might be searching for is collaborative process.
Thank you.
Mediation is a collaborative process. Everybody's working together against the problem, trying to solve the problem. You're not arguing with each other constantly about who's right and who's wrong and who did what and who's to blame. And my law school background is almost separate and apart from my mediation ability, I would say. It's really very different.
Well, let me ask one other question related to cost, and then I want to kind of get back to the mediation ability for a minute, if I may. Who pays? There's obviously cost involved in having a mediator present, just like there would be a judge and attorneys. Who pays for the mediation process?
Typically, both parties share in the expenses.
Equally?
Equally, and that's something that they can mediate. Sometimes one party's not able, financially, absolutely unable, especially, for example, in the case of somebody who's just lost their job and who has a dispute against their employer. And occasionally the deeper pocket will pick up the expense just to get a move on things. Typically in a divorce situation, for example, the parties will share, or if one party isn't earning an income, then maybe the other party will pick it all up.
We know from the introduction that Tony gave you that your law school training was at Rutgers. Where were you trained as a mediator?
I've been trained in several different trainings, originally in Idaho by Wendy Worth, Bob and Wendy Worth, and that was in strictly family mediation. And then I was trained by a wonderful trainer named Lynn Cox at the University of Washington. I spent a couple of days observing a former United States attorney named Sid Lezak out in Portland conducting employment mediations. I attended mediation training involving very high conflict divorces that was put on in Boise through the Idaho Mediation Association, and a psychologist named Janet Johnston who's worked with another psychologist, Dr. Judith Wallerstein, and they're very well known for learning about how high conflict divorces affect children for the rest of their lives. So that was very valuable. And I've attended a training put on by the University of California at Bolt Law School by one of the professors there, and another training at the University of California at San Diego. So it's one of those things that you get hooked and you just can't stop going because it's such a fascinating field, and there are so many skills always to be learned and so many different methods of looking at how to handle this kind of process.
Thank you.
Thank you.
You certainly have a really great lot of training in this process. I'm going to follow up on a couple of Steve's questions. First of all, I'm sure there are cases in which both the parties are without resources and funds. And the only way that mediation can take place is if they can have it without those. Is there something in place, or some attorneys volunteer, or the courts have sympathy? Certainly in a criminal matter, we have the public defender's office for those who cannot afford it. How do you deal with those cases when both parties are without resources?
Well, I guess there are different scenarios to imagine. The only answer I can give you that's absolutely founded in fact is that I have, along with I'm sure numerous other mediators, enlisted myself with the volunteer lawyers program of the state bar to render free mediation in a given case if necessary. And that's something that I believe the state bar first investigates and evaluates, and then they decide, yes, these parties need this, and we'll refer it out like that.
All of you to be commended for that, because that is available, and but certainly would not be used except in those cases where it was truly without any other
some
remedy.
Real financial means,
right.
Lack of means. But I guess one of the problems that you encounter as a mediator is to recognize that most people in dispute would probably look into mediation if they knew it was out there as a possibility, and that's why I was so happy to be able to come and tell people about it more today, because I don't think it's very well known yet, and deserves to be, because it's such an efficient, effective process. So if you've got hardly any financial resources, and you have a dispute that you believe there are some things you can negotiate about, you're probably more frugal to go visit a mediator first and hire an attorney afterwards if necessary than to go the more ordinary route.
We don't have a lot of time left, but there's another area I want to get covered before we break and then come back with you next week on the second show. But once there is an agreement reached in mediation, does one have the faith that no one will break the agreement, or do you assure it more by going back to court? I know in some cases the court then can put its stamp of approval, and then under court order that's more success. How do you guarantee that after someone sleeps on the issue, they will not say, I've decided to break the agreement?
Right. Well, to answer your first part of the question, yes, ordinarily these mediated agreements are in fact made part of a court order and given the stamp of approval of the court. I'm not quite sure that the court actually even gets into the substance of what's in there. They pretty much just, you guys have agreed, great, go away.
Yeah, you don't go back to court and have a trial and so
Right.
forth, and all that expense. And so
But, and the judge doesn't even read through the pages. It's good. I'm really happy you settled this. That's wonderful. And then it's enforced with all the enforceability of any court order, and it's enforced along the regular rules of contract so that it has to meet the same rules with regards to specificity and capability and all of the rules that apply to a regular contract. In the question as far as could somebody change their mind later, I haven't had that personally occur. I suppose it does, in which case you might mediate what to do in advance before you conclude your mediation. That might be something that comes up, because you're going to test this thing from every angle before you're done. But if it seems appropriate, that might be something that comes up. I personally haven't seen that come up.
on that note, I'd like to bring the program to conclusion. On behalf of our panel and our staff, Sheila Fisher, we thank you very much for being with us. And this is a very interesting subject, dealing with conflict resolution. And I want to now say to the viewers that you have been very cooperative with your time, and we want to thank you for returning again next week when we will get into some other areas of this whole issue. It really covers a big field, and I want to talk about whether or not the law schools are going to start using this more in the training of their attorneys, but we shall save those kind of questions for next week. And again, thank you very much.
Oh, absolutely, my pleasure. Thank you for having me. It's been wonderful.
It's been wonderful to have you here. And ladies and gentlemen, as I've indicated, we will have our guests back next week to continue our discussion in part 2 of conflict resolution. Until then, please have a good week. I am Tony Stewart.
North Idaho College Public Forum is the longest-running public television show of its type in North America and is seen in 7 states and 2 Canadian provinces. Each episode is pre-recorded live and is an educational community outreach from North Idaho College. Please join us again at this same time next week for another new edition of North Idaho College Public Forum on this public television station. From the shores of beautiful Lake Coeur d'Alene in the heart of North Idaho, local, regional, national, and international guests discuss their topics on our forum, the North Idaho College Public Forum, with your host and moderator, political scientist, Tony Stewart.
I welcome you to part 2 of our 2-week series that we are discussing conflict resolution. We're looking at mediation and the different processes that can oftentimes keep a case from going through court for years and being very expensive and also very stressful on everyone involved. Our guest is Sheila Penelope Fisher. She is an attorney in the state of Idaho. She's also approved by the Idaho courts as a mediator. She holds a BA degree from State University of New York at Old Westbury, and her doctorate in jurisprudence is from Rutgers University in the state of New Jersey. Sheila, welcome back to the program. We enjoyed last week and look forward to analyzing even in more depth this very important process that's become more and more popular within our judicial system.
Oh, likewise. Thank you for having me again.
And as always, I'm very pleased to have our two regular panelists, Janelle Burke, who's an attorney in the state of Idaho, and next to her is Steve Schenck, who is the Vice President of College Relations and Development at North Idaho College. And we shall invite Janelle Burke to commence today's questioning.
Last week we had a very interesting discussion about mediation, and I'd like to give you an opportunity to tell our viewers again, what is mediation and what are some of the benefits of mediation?
Yes, thank you. Mediation, again, is a process in which a trained neutral mediator assists parties in a dispute to reach an acceptable agreement on their own that they will then probably put through the courts to finalize. And it involves helping those parties figure out what their issues are and then to broaden their perspective from being very position-based to being more interest-based, learning how to generate and evaluate different options for solving the problem, and then reaching an agreement.
And what are some of the benefits of mediation as opposed to litigating a full case to its ultimate conclusion?
Yes, the basic benefit overall is that mediation is very well described as win-win. It really, truly is win-win. I've never seen parties leave mediation who weren't on both sides of the table just completely satisfied with the result that they achieved. And everybody knows court isn't even win-lose, it's almost lose-lose, because even when you've won in court, almost always you've invested an enormous amount of money, time, anguish in getting there.
Steve Schenck.
Sheila, I wrote down last week when we talked the word neutrality, and I noted it again as you were kind of warming us up for this week's show. How important is that in your role, and how difficult is it for you to stay neutral, maybe as you see the facts unveiling in a dispute, and your legal background and common sense says, well, this guy's clearly wrong and this guy's clearly right. How do you do that?
It's very difficult, and it's crucial. Mm-hmm. You can't mediate. If you've reached a bias in a case, from my ethical standpoint, I would withdraw at that point in time and just tell the parties, I'm sorry, I cannot continue. And I would make that clear in that original ground rule setting orientation session that you're free to leave at any time. If this process isn't working for you, then we'll be very sorry, but we'll have to disband at that point. And same thing for me. If I feel either that I'm becoming biased or that I don't feel that you all are working towards a negotiation in real good faith, I'll have the right to just stop it. And so it is crucial because you need both sides to believe, and rightfully so, that they are in control of the process. If you're going to side with one side, guess who's going to probably prevail or have a little bit more of the power in the negotiation? And each side needs to know and really truly have it be true that the mediator is on both parties' side, because it's all of us against that problem.
Another word I wrote down last week was misunderstanding. How often is that at the root of the problems that you see reaching you as a mediator?
Frequently. And to the extent that it isn't, that's fine, but you just want to make sure that you're not fighting over something that doesn't even exist as a real true problem because one person just misunderstands something.
Are there some things that lead to that in your experience? I mean, when two people have been at odds for some time, they've even gone to the point of hiring attorneys and at least making an initial appearance in court, and it's all over a misunderstanding. And the thing I'm thinking about oftentimes is a failure to listen, to try to understand the other person's. What things do you see as keys to the misunderstandings that come before you?
That same issue, communication and lack of ability to communicate. And often it's exactly what you just said, the inability to listen. and so a lot of times when you are in the middle of mediating, you'll realize that neither side really understood what the issues were before the mediation. They thought they did, but they really were missing some of the real basic points of why they were in dispute.
And if once you've been able to facilitate an understanding between the two, is a solution usually pretty close at hand?
Certainly, yes. And a lot of times the way that you elicit that understanding is to get into emotional issues that are often really neglected in a more traditional legal setting. And that, to me, is usually the key. Once you can break down the barriers and both sides really understand what it feels like to be on the other side, that's when they just break down their barriers against resolving the problem, and everything just sort of dissolves, and all of a sudden they just want to make things right.
Thank you.
Some years ago, the development of conflict resolution centers, peaceful resolution conferences, and the idea of mediation really grew out of a lot of community activists and social workers with attorneys. And I have to say, particularly in some examples I've seen, women attorneys became very supportive of this process because very used to dealing with trying to negotiate and bring people together. And the courts then recognized the merits of this process and have adopted and sanctioned it, such as in Idaho. And I've been here long enough to see that process. So my question is, since it is growing and it has had this success that you've alluded to on our program, now let's turn to the law schools, because the traditional law school obviously has trained people in the law and interpretation and so forth. Do you see law schools adopting this somewhat in their curricula too, that more future law students will come out of law school not only trained, and there is areas where there has to be adversary roles in the courts, like you're saying, we're trying to get a new interpretation of the law or something's clear, but is this an arm that the law school should look at, or are they doing so already?
I think it's certainly an arm that should be looked at, and they are already doing so, and there's plenty of room for growth in that area as well. In my experience at Rutgers, when I was there was a seminar offered in mediation, and unfortunately I took a different seminar that conflicted in its schedule, and I really didn't know what mediation was. And I knew the professor quite well who was giving that class, and I never even had a chance to ask her, what's that mediation stuff? I really didn't know. I first heard about it in the court that I was clerking in that had a program within the small claims court where they had mediators trying to resolve those cases. But I know also that at the University of California at Berkeley at Bolt Law School, there is a course offered. Again, it's not even there. It wasn't a seminar. It was several weeks course on a Saturday, and not a required course, just an elective. I believe locally here that Gonzaga University and the University of Idaho at Moscow have clinics, as I understand it, where law students are either in the community or in the courts handling some cases, perhaps in small claims, as mediators and trying to dispose of those cases in that way. So what I know, the limited amount of knowledge that I have about law school education at large, is I would be amazed if there's any place where there's a full-blown course in mediation that is widely attended by the whole class. You know, there may be
some things you have to,
like
courts or whatever.
Exactly. Certain core subject matters that everybody is forced to take, and you don't get a choice. You don't get to opt out from torts and real property
But
and
in
contracts.
the future, that might be.
I think it would be a wonderful, wonderful progression for it to be a mandatory course. Also, I'd like to point out that there are many, many extremely skillful mediators who are not lawyers and have no legal training whatsoever. And as you were indicating earlier, came to this through a more community-type route and are often social workers, counselors, even different kinds of clergy are involved in mediation. And those people can mediate legal disputes absolutely perfectly well. You don't need to be a lawyer to do an excellent job as a mediator in a full-blown, complicated legal dispute.
In some jurisdictions around the United States, the courts are really overworked. And to get on the docket and have your case heard, either a civil case, particular civil case, I know from U.S. Supreme Court decision, you can't just keep delaying certain criminal trials, and particularly if the person's incarcerated. But in civil matters, there's this tremendous backlog. And so through this mediation process, which you've indicated is removes off the court docket and also is a faster process. Are we reaching the point to where this is helping with the court load and allowing the cases that have to go to court to be expedited more rapidly by removing some of these that would become part of the work of the judges?
Yes, absolutely. There is, in many counties in Idaho, there is a settlement week that takes place, I believe, just once a year. And that moves an enormous number of cases off the existing docket from the trial calendar. If you were to mediate a case before it were even filed in court or even on the trial calendar in the court, that would prevent it from clogging up the arteries of the court system even before anybody were aware of the case's existence. So there's a great deal of ability for mediation to assist the courts in concentrating on the cases that really need to be tried. Now, it has always been a pattern that lawyers amongst themselves have in fact settled cases, and that's one thing we're taught in law school, that 80-something% of cases do settle before trial. But a lot of times they're in the court system meanwhile and clogging things up with a lot of motions and taking up an enormous amount of time that, as experience can show, was unnecessary. Had those disputants simply gone the route of mediation, they could have saved themselves and the court system all of that time and trouble. There are also cases that are currently not being mediated routinely, such as the criminal cases, where my personal belief is that there can be more and more diversion opportunities. And as I understand it, the northern Idaho counties are very active in that area and starting to look at it more and more, because there again, there are so many criminal cases which, even though they do have priority in the trial calendar, maybe don't really need to be tried if there were an adequate alternative.
Thank you. Janelle Berg.
Many kinds of cases are conducive to some kind of settlement process, mediation, but I want to talk specifically about family law cases, okay, because I think that's one of the areas that mediation is most successful in, and tends to alleviate a great deal of the animosity that can occur between the parties. Can you talk a little bit about the best interests of the children and why child custody is something that can sometimes be mediated very successfully?
Yes. Best interest is the concept that drives a family mediation. A child custody or visitation or grandparental visitation, anytime that there are children involved, we, the mediators, put out the concept of best interest of the child to the disputants, often the parents, to help them look at this problem from a whole different perspective. And that perspective is, fighting is going to hurt your kids and hurt them deeply and almost permanently. It's not something that a caring parent would voluntarily do to their child, and so here's how you want to start thinking about this problem. And we try to educate. There's an enormous amount of education that takes place in a family mediation. Oftentimes in this region, parents who come into mediation have already attended a parenting class, and so a lot of that work has already been done. And they're really very tuned to the concept, which is oftentimes new to them, of child development issues and also emotional concepts and what kind of harm can be done to those children if those best interests are not held in the utmost importance in their negotiation.
And divorce is a large penumbra of things, if you will. It's several things. It's the property rights, and of course it's the dissolution of the marriage, and it's the children's welfare. And how can all of those things work together in a mediation to settle all of them at once, or sometimes only to settle a part of it?
Right. Well, a lot of times the mediation starts around the concept of child custody, mainly because I believe that's the area where the judges really feel less well equipped to make that decision than the parties themselves could do, because nobody knows these children better than the parents. To have a judge who probably won't even ever speak to those children make a decision about custody is just an alien concept. It's frightening. It makes no sense when you start to imagine it as contrasted to the idea of the parents themselves, who have known the child since birth, figuring out what to do. And so that is an area that just completely lends itself to mediation. Sometimes after disputants see how easy that was, gosh, I didn't think we could do that, but we did, then they'll approach the mediator to go forward. Well, we've got these other issues here. Maybe we can get them resolved as well. If they're already represented by their own attorneys, that might be a point in the negotiation where it would really make more sense for the attorneys to attend the mediation together with their clients. Perhaps not, but a lot of times what you wind up doing is first concentrating on the child custody issues, the visitation issues, and then going into the property. And sometimes it just happens to flow better and work better to just sort of do a little of all of these things in the same session. Mediation could go on for a whole day at once. If everybody's got the time, you could just sit down and put aside the day and see how long it takes to get how far. Sometimes you just go on an hourly and meet again a few days later or a week later and sort of do it. But there could be times when all of those different concepts and issues come into play in the same session, just to divert. If you're not getting anywhere talking about custody, well, maybe we can talk about what to do with some property issues and come back to the custody after maybe we've solved something easy like who's getting the china or whatever.
Sheila, my next question is a little bit unfair because I'm going to ask you to speak for someone you're not. But in your view, when a judge decides to offer mediation as an alternative in a child custody case or in a civil suit between business adversaries, is he or she making that decision primarily, do you think, on the basis of the facts or the issues involved in the case, or on an opinion of whether or not the disputants have the ability to benefit from mediation?
I could almost say both. I believe the Idaho judiciary specifically is incredibly well informed about mediation. We've had at least 2 Supreme Court justices whom I'm aware of, both Chief Justice Trout and Justice Silac, have been incredibly active in bringing mediation into the forefront of the Idaho justice system. And it's just trickled down. Everybody knows about mediation anymore. The magistrates who handle family cases, when I believe in all counties, or certainly in many counties, any case that's going into the family courts for divorce will automatically somehow advise the parties of the concept and availability of mediation. I'm not sure that each county handles this kind of orientation in the exact same way, but in both counties that I'm familiar with, there's some sort of process in place to make sure that the parties understand that it's an option. So that's a given. Then, if the judge actually decides to order that case in, my own personal experience, that was a case where I think the judge really hoped that the parties themselves were going to learn to be a little bit more realistic and cooperative, because they were at each other's throats to such a degree. It wasn't that he couldn't control the courtroom, but he couldn't stand being in the courtroom. It was just too aggravating to put up with these parties, and he'd already learned this enough from the motions. He didn't want to go into trial with these people. And so there are times when the case is ordered out because everybody realizes that it's routine and it's quite likely that mediation will solve the problem. And then there are times when it's ordered out because it is win-win, and at least even if they don't reach an agreement, they'll probably come into court totally different from when you last saw them, and a little bit more relaxed and reasonable.
My next question is very closely related. In your own experience, in those mediations that have failed, is it generally because the case simply didn't lend itself to a negotiated agreement, or were the participants unwilling to find one?
You know, I personally have not been involved in a mediation that has failed, but I have not done a huge number of mediations. However, in all of the times when I've observed mediations and in numerous anecdotes talking to other mediators, I think that's a normal pattern for mediation. I think that it succeeds far more frequently than it does not. And I think that when it fails, it can only be because the parties were unable to resolve it. I don't think it can ever be because it was too complicated or the law was too complex. But as I said at the very beginning of last week, there are cases that simply cannot be adequately mediated. If you have a dispute over the law or you're trying to break new grounds in the law, that's the kind of case that it's not going to get mediated. I just personally perhaps haven't accepted a case like that or been referred a case like that. But you know,
Those
the dog
shouldn't get to
variety
mediation in the first place.
I'm sorry?
Those cases shouldn't go to mediation in the first place.
And probably won't go to mediation.
Thank you.
Because one party just won't agree. It does take two to enter it, and one party's going to say, not me.
Thank you very much.
My next question deals with process and rules again. I'm very much oriented towards that in hearing your comments. When you have a case that has quite a few complexities or several issues on the table, do you have an order of those? And what I'm thinking of is, I assume some of those issues are easier to resolve than others. Do you take them in a certain order that if you have certain success, you may increase the chances of success on others? Is there, in your own professional work, do you think that is important that you, once you've identified those issues, you may address them in a certain order?
Yes. It really helps to build on success. And so you constantly, as a mediator, are pointing out agreements and successes all the way through the process. And it's very infectious, I suppose. You congratulate the parties for coming to mediation. Some parties can't. Some parties won't. These parties have. That's fantastic. We're so glad to be here together. We can make this work. It's really from the get-go. The fact that they came is a success.
There's a psychological thing
I mean,
involved
it's not
here,
just
too?
mumbo jumbo. It's true. It really is true. And once the parties themselves, I suppose, and based on trainings where we've done a lot of role plays and stuff, I think that's true, that you start to see yourself in a different light. Like, it does start a psychological progression that takes place.
One more question back to Janelle.
Sure.
People are very different. Some people have a much longer attention span than others. So do you make judgment calls? In some mediations, it's not wise to have very long sessions that people get tired, and other times they're having success, and it is. Do you make judgment calls as you're seeing the personalities involved?
Yes, that's a great deal of what the mediator does, because I see myself in the role of the guard and the guide. So I'm guiding people through the process, and I'm guarding the process itself and making certain that everybody's comfortable and feeling good. And if somebody's tired and worn out and can't take it anymore, then we really should stop now.
Thank you.
Yeah.
If people are going to hire a mediator, of course, they want someone who is reliable, who is well-trained, and so forth. And so where might they go to find a mediator? And realizing that our viewing audience is not just Idaho, but other places as well, there are some organizations that do that actually people belong to if they're professionals. Can you tell us about some of those so people would know where to go?
Oh, certainly. First of all, I would imagine that in all states, the state bar has some ability to explain to somebody who were to call asking for a mediator how to locate one. And probably almost probably every state now has a state mediators association. Idaho certainly does. There are national organizations, quite a few of them. One of them is SPIDER. It's the Society for Professionals in Dispute Resolution. And it's got a very wide breadth of mediators who are doing all kinds of different types of mediation in it. There's the Academy of Family Mediators, which, as the name implies, is attended and is joined by family mediators. Here in Idaho, there's the Idaho Mediation Association. I'm sure there are many more that I'm not aware of. The ABA does have an alternative dispute resolution section, and I suppose that might be one way that people could get names. There's ends dispute, there's jams, there's societies that are largely their membership is largely retired judges. I think JAMS is pretty well known for having a large number of retired judges who...
On that note, I have to bring the program conclusion. The
Okay.
clock always wins out on this program. Sheila, Penelope, Fisher, thank you very much for being with us. We very much enjoyed our 2 weeks with you on conflict resolution mediation. You've been very helpful to our viewers.
Okay.
And we appreciate the time that we've had with you, and good luck to you and all the others that are involved in mediation across the country. It has been a very important contribution to the court system and to people's conflicts. And again, thank you for giving us all this time.
Oh, absolutely. Thank you.
Ladies and gentlemen, as you know, our program this 2 weeks has been on conflict resolution, and we certainly bring you all of our programs with the intent of trying to be assistance in providing information that we think is valuable to you. I'd like to invite you to be with us again next week at the same time when we will move to yet another issue. Until then, please have a good week. I am Tony Stewart.
North Idaho College Public Forum is the longest-running public television show of its type in North America and is seen in 7 states and 2 Canadian provinces. Each episode is pre-recorded live and is an educational community outreach from North Idaho College. Please join us again at this same time next week for another new edition of North Idaho College Public Forum on this public television station.